Hello and welcome. I'm Lakisha Dean, a family law attorney with over 15 years of experience helping families navigate the complexities of custody and relocation issues. Today, I want to talk to you about an incredibly important topic for parents here in New Jersey, which is the potential consequences of moving out of the state with your child without the express consent of the other parent. Now, as a parent, the desire to provide the best for your child is always at the forefront of your mind. However, decisions like relocating can have significant, lasting impacts, not just on your life, but on your child's well-being and your relationship with them. In our discussion today, we'll delve into the case law surrounding this issue, specifically the Bisbing versus Bisbing case, which highlights essential factors that the courts consider when it comes to custody arrangements and parental rights. I'll also share a real-life experience of a client who unfortunately thought she could move without a hitch, only to face unexpected challenges that altered her family's dynamics forever. So my goal is to ensure that you're equipped with the right information and guidance before making any decisions that could affect your family's future. So, whether you're contemplating a move or you're just curious about your rights as a parent, I encourage you to stay with me. Let's explore this important topic together and ensure you're making informed decisions for your family. So, first things first, if you are the co-parent and are separated and have an existing custody agreement, make sure you understand the agreement and you are not at risk of violating it. Now, some custody orders have specific provisions about relocating. If you have sole custody, you may have more leeway and will be able to move. However, if you share joint legal custody, even if you are the parent of primary residence and you're asking to move, you will still need to gain permission of either the co-parent or the court. Let me make that clear. You'll still need to gain permission from either the co-parent or the court. If you need to know the difference between sole and legal custody, please go to my YouTube page to watch the video explaining the difference. Now, once you plan to move, you must notify the other parent. That sounds obvious, but a lot of people make that mistake. Make sure you ask for permission to move the child outside of the state. Remember, no one can technically stop you from moving, but if your goal is to move your child, you cannot do this without consent. Now, here's a tip. When you're seeking permission, please do so in writing. It does not have to be a formal letter. A simple email or a text will do, but you want to document the fact that you are reaching out to seek permission from the other parent. You have to account for the fact that the other parent may say that you did not. Even though you may feel that you have permission, it needs to be expressed so that when you get to court, it will not be an issue, because credibility will be a huge factor in helping the judge decide your case. You want to make sure that you can prove that you tried to communicate to the other parent about your request to move the child and that you acted in good faith. Now, when you do communicate your desire to move, be sure to include details about your new location and the reasons for the move. This is not the time that you want to make this a mystery or you want to hold back too much. And this is really important because it opens the door for communication and reduces potential conflict. If the other parent agrees to the move, then that's fantastic. However, if they don't, you will need to file a motion with the court. Now, mind you, if they do, make sure you get it in writing, okay? But if they don't, you're going to have to file a motion with the court. Now, the court will consider various factors based on the Bisbing case I just mentioned earlier, some of which I will discuss later. Now, timing is usually of the essence in these cases, so you don't want to wait until it's about 1 month from your move for you to file your motion. These cases can take a few months before you get a decision from the court. For instance, For a case where one of my clients wanted to move with her child at the start of the school year, so meaning around September, late August, we filed in January and did not get a trial date until August, right before the first days of school. Usually, though, the court will try to get the parties to agree on their own and send them to mediation first. If this doesn't work, it will schedule a trial or plenary hearing, is what we call it, where each side will get to present evidence to support their case. This is where legal representation is very, very important. In this type of case, since a trial will be held and not a summary hearing, which means that you'll just get up to make your case for about 20 minutes or so, that's not the case. The court will expect you to know how to present evidence and the rules of evidence. This is a trial, ladies and gentlemen. Like I said, it's not a quick hearing, so don't risk having important information excluded from the trial simply because you did not know how to admit it or allow the judge to consider it. The judge is going to hold you to the same standard it would hold me or any other attorney. Now, the trial itself may take several hours or an entire day, depending on how much evidence and testimony are presented. So make sure you are prepared, period. This is a huge investment of time, energy, and emotion, and you don't want to waste it. Now that we've set the stage, let's dive into the legal framework that governs relocation cases in New Jersey, particularly focusing on the significant case of Bisbing versus Bisbee. Now, in this landmark case, the court outlined several critical, maybe crucial factors that must be considered when one parent wishes to relocate with a child. These factors help in evaluating the best interests of the child, and understanding them can be very important for any parent who's considering a move. Now, in order to grant the parent permission to move with the child, the court has to find that the move is in the child's best interest. Okay? That's a hefty standard. The first factor we need to discuss is the parties' ability to agree, communicate, and cooperate, things that I talk about pretty often, but regarding matters relating to the child. When parents can effectively communicate and collaborate or cooperate, it leaves a strong foundation for making decisions that are in the best interest of their child. Now, if there's a history of conflict or a lack of cooperation, the court may be less inclined to approve a move, as it could disrupt the child's stability and emotional well-being. Next, let's consider another factor, which is the needs of the child. Every child has unique needs that must be taken into account. This includes their educational requirements, emotional support, and social connections. A move can significantly impact these areas, and the court will assess whether the relocation would serve or hinder the child's overall development. Now, as a practice tip, I usually suggest that clients identify ahead of time the school, pediatrician, dentist, and any activities that the child will need to continue in their new environment. So what does this look like? If you can, find a school that is better than, or at least equivalent to, the school your child currently attends in New Jersey. And if your child has an IEP or 504, make sure you confirm that the school can continue this. Usually that is the case, but you want to show that you've actually done the legwork ahead of time. Now, if your child is in therapy, make sure that therapy can continue in the new state, either by telehealth or find a new therapist. The point is to make sure your child's needs are brought to the court's attention and that they can continue to be met in the child's new environment. Now, finally, one of the last factors that I will review is the extent and quality of the time spent with the child prior to or following the separation. Now, this factor examines how involved each parent is in the child's life. The more time spent or a parent has spent with their child, the stronger their claim may be to maintain that relationship. That's really, really important, especially in the context of a move. If one parent has been significantly involved, courts tend to be more protective of that relationship when considering relocation requests. I tell most of my clients that these cases are some of the most difficult for judges to decide. Just think about it. If both parents live in New Jersey and each spends their own time with the child, if one parent is then seeking to move to the West Coast and the other parent goes from seeing the child at a minimum from every week to only during school and summer breaks, this has a huge impact on the parent and child relationship. Now, judges know this and find it very difficult to tell the parent who remains here in New Jersey that they can only see their child during breaks. So, consider all of this, because together, these factors create a framework that courts use to evaluate relocation requests, ensuring that any decision made is ultimately for the best interests of the child. So, if you're considering a move, it's essential to assess your situation against these factors. Understanding the legal landscape can help you avoid complications and ensure that you're acting in your child's best interests. Next, I'm going to discuss the emotional and practical pain points associated with relocating without consent, and I'm going to share a cautionary tale from a client's experience. So, now that we've explored the legal factors surrounding relocation and the potential impacts on your child, let's talk a little bit about the emotional and practical realities you may face if you decide to move without the other parent's consent. So the decision to relocate can be both exciting and daunting. However, it's really critical that you understand that moving without the other parent's agreement can lead to serious legal repercussions. Many parents underestimate the complexities involved, thinking that a simple conversation or verbal agreement is enough. But unfortunately, this can lead to misunderstandings and possibly even custody disputes. So let me take a moment now to share the story of a client I worked with. She believed she had the green light to move to a southern state with her child after having what she thought was a mutual understanding with her ex-partner. Initially, everything seemed fine, but soon after the move, her ex-partner contested the relocation. He filed a motion in court arguing that it was detrimental to their child's relationship with him. So this led to my client now having to go through a lengthy and emotionally draining legal battle for which she will most likely have to return to New Jersey. Now remember, she's already moved, thinking she has consent. So because the judge then ordered 50-50 custody until the hearing, she now has to commute back and forth to make sure the child is in New Jersey for visits with her ex-partner. This is not what she had hoped for. Now, the cost to commute alone is a burden for her, not to mention the idea of having to leave her child behind for a week. And here's the kicker. The judge ordered equal parenting time, which was not even in place before. And it has not only affected her life, my client's life, but it has also impacted her older child and the entire family dynamic. They faced significant adjustments, emotional strain, and financial costs that could have been avoided had she sought legal counsel before making such a pivotal decision, or at least getting it in writing that her ex-partner agreed to allow not only her, but the child to move. That's really what was at issue in her case. Now, this story serves as a cautionary tale. The emotional toll of custody disputes can be overwhelming, not just for parents, but for children as well. It's vital to think about the long-term impact of your choices and how they can affect your child's stability and happiness. If you're contemplating a move or have questions about custody and parental rights, I cannot stress enough how important it is to reach out for legal advice. Consulting with an experienced family law attorney can help you navigate these complicated waters and ensure that you are making informed decisions that prioritize your child's well-being. Please don't hesitate to give me a call at 856-359-5222. Again,
That is 856-359-5222, or visit my website at lakishadeanlaw.com. That's LIKSHADEAN law.com. I'm here to help. If you find yourself in this situation, don't hesitate to contact me for a consultation. Let's work together to ensure your family's future is secure and that you're prepared for whatever lies ahead. I want to thank you for joining me today. I hope this discussion has been informative and has given you the tools to approach your situation with clarity and confidence. If you found this video helpful, please share it with fellow parents who may also benefit from this information. Together, we can empower families to make the best decisions for their children. Take care.